All right, so we're on the record in docket 23-03-475. That is People of the State of Michigan versus Aaron Austin. Will the parties please introduce themselves for the record? Ms. Grant.
May it please this honorable court, Stephen Grant, P51260, Assistant Attorney General on behalf of the people. Good morning.
And Mr. Feigelson.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, on behalf of Aaron Austin, who's standing to my left this morning, Your Honor.
And sir, you are Aaron Austin, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination today. Ms. Grant, how we proceed?
Your Honor, Mr. Feigelson has indicated that his client wishes to waive his right to a preliminary examination, and people have no objection.
Okay. Mr. Grant, Mr. Feigelson, is that a correct statement?
It is an accurate statement. We wish to unconditionally waive our right to an exam this morning, Your Honor.
And is there anything you'd like to place on the record or negotiations to continue?
Negotiate. Get out of my tongue. Negotiations will continue in circuit court.
And that's a fair statement, Ms. Grant.
Yes, Your Honor.
Mr. Feigelson, may I inquire of your client of his waiver of the preliminary examination?
May, Your Honor.
All right, Mr. Austin, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Stephen Feigelson, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan through Ms. Grant. Do you understand that, sir?
Yes, sir.
All right. Is it your wish today to waive your right to a preliminary examination in district court, have this case bound over to circuit court as charged with negotiations to continue? That's my understanding. It is your wish to waive your right to a prelim today. Is that correct?
Yes, sir. It is.
All right. Do the people also waive their right to a prelim?
Yes, Your Honor.
All right. Thank you. I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made as charged with negotiations to continue. And I'll have each party sign the bind over. Okay. All right, so I'm in possession of docket 23-03-475. Both parties have signed the bind over. I will also indicate for the record. Make sure I get that right. And sign the bind over. Right, Mr. Austin, your time in district court is done. You'll get your next date in circuit court from your attorney, Mr. Feigelson.
All
right, sir?
All right. Thank you.
All right. Any questions concerning 23-03-475, Ms. Grant?
No, Your Honor.
Mr. Feigelson.
None, Your Honor. Thank you.
All right, thank you. That's all for the record. It's good to see you, Ms. Grant.
It's
Take your time.
wonderful
Have
to
a
be
nice day.
here. I love appearing places where people love what they do. It's a wonderful thing.
I'm glad to hear it. Thank you.
Take care, Your Honor. Nice to see you.
All right, Mr. Feigelson, nice to see you too.
I'm not sure. I think they're using our court.
Yeah, I don't know what to do.
So Abby is such a.
I've adjourned it twice, I think. Adjourned it once. It was left on. That's all. In docket 2303-495. That is people of the state of Michigan versus Justin Mauer. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Justin Mauer, who stands to my right.
Sir, you are Justin Mauer, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is going to be a waiver of the circuit, as charged, with the understanding that at circuit, Mr. Mauer would be given the opportunity to plead to 2 counts of possession at pretrial. And no upfront jail.
Okay, so the offer's been placed on the record, but this will be bound over as charged, and then the counts will be amended in circuit court.
Correct.
And is that a fair statement, Mr. Palmer?
It is a fair statement, Your Honor, and just to be clear, it's not, I want to make this very clear, it's not by any means binding on Ms. Wilson, but the defense intends to seek HYTA status. Those negotiations will continue in circuit court. Mr. Mauer is eligible for HYTA by about 3 weeks, birthday wise. So that there, I anticipate ongoing negotiations in the circuit court, but yes, at this time, that's an accurate statement.
All right. And is that your understanding, Ms. Wilson?
It is, Your Honor.
All right. May I inquire your client of his waivers preliminary examination?
Of course, Judge.
Mr. Mauer, you understand you have a right to preliminary examination today in today's court. A preliminary examination is a probable cause hearing in which Ms. Wilson would have to prove by on behalf of people that in each one of these 2 counts that a crime was committed and the identity of the person who committed that crime. You are represented today by Mr. Palmer, Attorney Paul Palmer, and he would be present to cross-examine any charges or cross-examine any witness or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, I understand.
It's my understanding that the offer's been there's been an offer based on the record. We're binding over as charged today, but it is your intent to waive your right to a preliminary examination and have this case continue to circuit court based on the offer that was made. Is that my understanding?
Yes, sir.
All right. And Ms. Wilson, you also waive your right to preliminary examination?
Yes, Your Honor. The people unconditionally waive their right.
All right. I'll have the defendant and counsel sign the preliminary examination bind over. I'm in possession of the bind over paperwork on 2303-495. I'll indicate that the exam was waived on today's date. That's February 22nd. And I will sign the bind over document. So, Mr. Mauer, your time in district court is done. You'll get your next date from your attorney, Mr. Palmer, in circuit court, probably in about 2 weeks. Okay, sir?
Yes, sir.
Anything else for the record in 2303-495, Ms. Wilson?
Nothing from the people.
Mr. Palmer?
Nothing from the judge.
All right, Mr. Mauer, good luck to you.
Thank you, sir. You have a wonderful day.
You were talking to Ms. Donnelly, and I think Mr. Silverthorne's talking to his
Mr.
client.
Silverthorne's downstairs. I believe Mr. Freeman's downstairs. Miss Donnelly is roaming. Mr. Ray is here. I believe he is still unrepresented.
All right. And then Ms. Reed is in Eaton County.
Correct. And I
Right.
believe I saw Miss Wanji. I think she's in another courtroom somewhere.
All right. Mr. Ray's unrepresented. Let's call that case and see where we're at.
Yeah, right. Yeah.
So since we know Mr. Ray's unrepresented, let's go ahead and call that case.
Okay.
And then if it's
Your
gonna be a prelim, we can hold off till we move some other cases.
Honor- Okay, sounds good.
Because
Yeah.
I just don't know if he's right. So Mr. Ray, you can come up here. You can have a seat right there. So on the record, docket 24-00104, that's people of the state of Michigan versus Darian Ray. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
And sir, you are Darian Ray, is that correct? This is the time set for preliminary examination. I'm going to indicate for the record that we had a probable cause conference on January 26, 2024. I was at that time that Mr. Ray was seeking an attorney. We had a preliminary examination on February 2nd, and there was good cause to adjourn because Mr. Ray was still seeking an attorney. He'd been denied the Ingham County Public Defender's Office on January 16th, 2024. So I say roughly 2 weeks ago. Yeah, 2 weeks ago. And now, so 2 weeks, now we're February 22nd, which is a little past a month from when he was denied. Ms. Wilson, how do the people want to proceed on this case?
Thank you, Your Honor. At this point, I'm a little concerned about Mr. Ray waiving any rights without counsel. So I believe the people are prepared to proceed with the preliminary exam today if the court is inclined.
All right. Mr. Ray, you are without counsel today. And it's been about a month, it's been over a month since you've been denied counsel you applied for the Public Defender's Office and denied counsel. So I guess I need to hear from you. What is your intent to do today?
I guess continue I don't.
Do you plan on getting a lawyer?
I've tried, but they just saying ridiculous amounts. I just make all this money or something. I'm not sure.
Did you reapply for the Ingham County Public Defender's Office?
Twice, and they denied me again yesterday morning.
So you have 2 denials from the Ingham County Public Defender's Office, and you don't. Here's my problem. I can adjourn this 2 weeks, but if you still don't have a lawyer, you still don't have a lawyer. I mean, it doesn't seem like you doesn't seem like you're gonna have an attorney.
Right, exactly.
So you should have a lawyer at prelim, but you can't get the Public Defender's Office. I can't go find a lawyer for you.
Right.
So you're gonna have to find one, and it doesn't seem like any of that's worked out for you. So is it your intent today to have a lawyer?
Yeah, I would like a lawyer here with me, but every time I call, they say something ridiculous. I'm not even sure why this is my first, charge I ever had.
You have a felony, you have a weapons felony, a 5-year felony, I think, in front of us that you're looking at prelim. So, I mean, you need a lawyer. You need to pay whatever it takes, okay? If you don't, then you don't have nobody here to represent you. Now, Miss Wilson's been patient, but do you have witnesses
I have
here?
witnesses
How many
here.
witnesses do you have?
I believe I have 2.
Both law enforcement?
Yes.
And it doesn't do me any good to adjourn this if you don't plan on getting a lawyer. I see somebody raising their hand back there. You're an adult, and so do you plan on getting a lawyer or not? He's looking. He needs to consult with you. You've been sitting at the back of the room together for like 45 minutes. You had to see this coming, that he doesn't have a lawyer today, that, that this is the day of a prelim. We've already adjourned it. Do you need time to talk to her?
I mean, I don't know, not really. I don't see no outcome changing. Like, they're denying me for public offender, but
You've
everybody I
denied,
call is
and you've been denied twice. Is that correct?
correct.
So you were denied on January 16th, 2024, and then you were denied yesterday morning.
Correct.
So that would be the 21st. Mr. Ray, what I'm going to do is hold off. You obviously need to talk to somebody who's here for you. So I'm going to give you 10 minutes to talk, to get out in the, this is much serious an event that you're treating it right now. Okay. You have a 2,500 PR bond now, and you don't have a lawyer. So we got a problem. Okay. And we've adjourned this several times, and you've been denied by the public defender's office twice. So let's take a break. Let's have you talk to whoever has come as your support person, who keeps raising her hand in this regard, because I know she wants to talk to you. This is the time to start taking this seriously. All right. You can shake your head all you want, but if you don't have a lawyer and we're going to prelim, you're creating bigger problems for yourself. Okay.
Mhm.
All right. So let's take 10. Ma'am, you can talk to him. I'd talk to him outside. Okay. All right, so we're on the record in docket 24-00296. That is People of the State of Michigan versus Charles Ross. Parties appearances for the record, Ms. Wilson,
Abigail Wilson for the people.
Ms. Thomas.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Charles Ross, who is present and standing to my right.
And sir, you are Charles Ross, is that correct?
Yes, sir.
Thank you. This is the time set for preliminary examination today. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe this is gonna be a waiver of the preliminary examination. Defendant would be bound over as charged in the complaint.
Is that a fair statement, Ms. Donnelly? It's a waiver of the prelim with negotiations to continue in circuit court.
Yes, Your Honor.
May I inquire of your client of their waiver of the preliminary examination?
Yes, Your Honor.
Mr. Ross, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by lawyer Ms. Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought by the people of the state of Michigan. Do you understand that, sir?
Yes, sir.
It's my understanding it is your wish today to waive your right to a preliminary examination, have be done in district court, and have this case continue in circuit court where negotiations are going to continue. Is that your wish today, to waive your right to a preliminary examination? Yes. All right. And Ms. Wilson, do you also waive the people's right to preliminary
Thank you,
examination?
Your Honor. The people unconditionally waive the right to an exam today.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over for signature. For the party's signature. I'm in possession of the bind over that's been signed by all the parties on 24-0029. I will sign it. The prelim was waived on today's date. I will sign it to that effect. Anything else for the record in docket 24-00296, Ms. Wilson?
Nothing for the people.
Ms. Donnelly?
Nothing for defense.
All right, Mr. Ross, you're done in district court now. Your next date will be in circuit court, and you'll get that from Ms. Donnelly. Okay, sir?
Yes, sir.
All right, thank you.
Yes, sir. Thank you.
Let's call Mr. Ray up here. Mr. Ray, this is, we're back on the record in 24-00104. People of the state of Michigan versus Darian Ray. And Mr. Ray, you've had an opportunity to speak with, now I know your mother is here. And there's an indication that that there's been discussions with the public defender's office, a concern between your family and the public defender's office, that you may have some medical issues, but also you're working overtime in regards to this issue. So it's obvious to me that you want a lawyer at this proceeding. Is that correct?
Right.
All right. And I believe you should have a lawyer at this proceeding. The prosecutor believes you should have a lawyer at this proceeding. We all believe that you should be represented and your rights should be protected this hearing. In order to do that, I'm going to adjourn this matter, but I'm going to have you waive one of your rights. All right. And I'll explain that to you. Okay. And the prosecutor has her witnesses here. We don't normally do this, but this will provide you some time to figure out your financial status, because you may have to make less to get a public defender.
Right.
And I know that sounds counterintuitive on some level, doesn't sound right. But you might fall within the cracks of making too much and therefore they can't give you assistance. So you need to figure that out, but I want to give you some time to figure that out, all right?
Okay.
So I'm gonna have you waived, what in, and so hopefully when we adjourn this and we get a new date, we can do this. I'll be the same judge on the case, but that'll give you some time to work some of these financial issues out. So you have a lawyer for your prelim on this felony, okay? It's a weapons felony case. So you have a right to a preliminary examination within 21 days. You understand that, sir?
Sir.
Okay, and a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence of the identity of the person who committed that crime, okay, in the file, and that a crime was committed, all right? And they do that by Ms. Wilson would call witnesses, and that's why you should be represented, because those witnesses should be cross-examined, and any liberty interest that you have, you should have a lawyer here to protect, okay? You have a right to that prelim within 21 days, and I've already adjourned this once for good cause because you didn't have a lawyer. And now I understand why, okay? All right, so what I'm gonna ask of you today is, if you waive your right to a prelim within 21 days, you're not waiving your right to a prelim in general. You're just waiving your right to a prelim within that 21-day period. Then that'll give you some time to try to seek financial, either work this out. So you have a lawyer present for your prelim, because it's obvious to me that that's what you want.
Right.
So is it your intent today to waive your right to a prelim within 21 days?
Yes, sir.
And do the people also waive their right to a prelim within 21 days, Ms. Wilson?
We do, Your Honor.
Okay. So I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And what we're gonna do is, because we've had witnesses show up on this, we're gonna get a new date and then test that with your date. And you can explain to them why we've adjourned. And we do have a waiver. So a new date, 30 days out.
March 21st at 8:30.
So try March 21st at 8:30. Did you want to try that?
Yeah.
And then,
Give me 1 second.
all right. Was that date again? March 21st. Might have to go, we'll see what they come back with. But a plan B would be the 28th. Does that work? Ms. Wilson, does that date work?
Yes, it does, Your Honor.
So we'll adjourn to March 21st at 8:30. You'll get notice from my court officer, all right? I do know that you've had I know the public defenders, your family's had contact with the public defender's office, and then you've had more contact today, okay? But on March 21st, if you don't have counsel, I'm put in a position where we have to go that day,
Right.
because we're gonna have witnesses there, and that shouldn't be a thing. on a probable cause hearing in district court. But I do understand now the nature of how you might be falling through the cracks, where you're making too much money for public assistance, but you don't make enough money to retain an attorney. And so let's see if we can fix that. We'll put this about to the March 21st date. All right, Mr. Ray? All right. Any questions, Ms. Wilson?
Nothing for the people.
All right. You're all set. I'll see you on March 21st, okay? All right, thank you.
And then, Your Honor, if I could have a moment before we call the next.
Sure,
witness.
yeah,
Thank you.
absolutely. So Ms. Wanja, you're here on Ms. Reed, right?
Yes, Your Honor.
I think she's in Eaton County, right?
That's what I heard.
Yeah, all right. And then Mr. Silverthorne, you're here on Mr. Walker, correct?
Yes, Your Honor.
All right. All right, so we're on the record in docket 23-03808. That is People of the State of Michigan versus Octavia Reed. Will the parties please introduce themselves for the record? Ms. Wilson,
Abigail Wilson for the people.
Ms. Wanchi.
Good morning, Your Honor. And you watch for Miss Reed.
This is the time set for preliminary examination today, and it's come to the court's attention that Ms. Reed is presently incarcerated in the Eaton County Jail. And is that a fair statement? We found out, I think our staff found out yesterday.
That is correct, Your Honor. I received a phone call from one of the officers in this matter yesterday. He was at a probation violation hearing in Eaton County for Miss Reed, and he informed me that as a result of that hearing, she was remanded to the Eaton County Jail. And then I conveyed that information to Ms. Wanji and the court officers.
County Jail. And did she make bond on this case?
I want to say it was either a cash bond or a PR bond. She was not in custody.
It is 20,000, 10%.
She posted it.
She posted a surety. And that's your understanding, Ms. Wanji, that she is in the Eden County Jail on it sounds like on a probation violation.
Yes, Your Honor.
All right. I'll indicate that she was previously waived her 21-day rule on January 11th, 2024. So we don't have a 21-day problem. I would ask Ms. Reed, I would ask Ms. Wanji, and this is really up, she's made bond on this file, but she's not getting any time on this file. But I don't know if you want to do anything without your client.
I don't want to do anything about my client, without my client.
All right. All right. So in Eaton County Jail, but she's not getting credit at this time until you talk to her. Because I don't know how long she's in the Eaton County Jail. All right, with that understanding, we'll adjourn today's preliminary examination. And we'll reset for time to read her out.
March 7th.
So March 7th at 9 a.m. Anything else for the record in 23-03808, Ms. Wilson?
Nothing from the people.
Ms. Wanji.
Nothing else.
All right, you're all set. Thank you for your appearance today.
Okay, Your Honor. Thank you.
Bring up Mr. Walker.
And which one are we gonna start with? I can be, if your client just needs to say that he is agreeing to leave up with the additional count, and then the new information will be filed with the addition. Okay, yeah. Your Honor, maybe approach.
Sure.
It's a tactical procedural, because of it just.
All right. And that'd be a fair statement, Mr. Silverthorne. We can call both cases together.
Yes, please.
Waive them both up.
Please,
All
Your
right.
Honor.
So we're on the record in docket 23-03-607 and 23-03-443. That's people of the state of Michigan versus Jamone Walker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Dwayne Silverthorne from the Office of Public Defender on behalf of Jamal and Joseph Walker, who is standing at council table to my right.
And sir, you are Jamone Joseph Walker, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant will be waiving his right to a preliminary exam today on both files. With the acknowledgement that on both files, there would be an added count of witness interference.
All right, and so correct me, I've added, so this would be and this will be part of the bind over notice that's signed. On file 23-03-607, there'll be the bind over is charged and the added count 2 of witness interference pursuant to 750.1227A. It's a 4-year or $5,000, and that has the potential for consecutive sentence. Is that correct?
That is correct, Your Honor.
And then on 23-03-443, that is bound over, the request is to bind over on as charged on the complaint, and then add account 4 of witness interference pursuant to 750.1227A. That's a 4-year and/or $5,000, and also the potential for consecutive sentencing. Is that correct, ma'am?
That is correct, Your Honor.
Mr. Silverthorne, is that your understanding of the bind over, the waiver of the bind over?
Yes, Your Honor. If I could make a statement though also.
Sure.
It's implied by this waiver, by the form of this waiver, that there is no plea agreement, but this wasn't without discussion that there could be multiple, in fact, quite a few potential witness interference charges that could have been issued. And only these 2 that are being added are going to be going up, and that negotiations are going to continue in circuit court. And it's an express goal that there be a global resolution, not of just these 2 cases, but also of a pending probation violation hearing before Judge Aquilina in case number 2518 FH.
And that's your understanding, Ms. Wilson?
It is, Your Honor, and I will also add that the defendant does have a misdemeanor charge in front of Your Honor that's with the same victim. I'm not currently intending on adding a witness interference to that offense, but there is the possibility, depending on what happens in circuit, that could be resolved as part of a global as well.
And that's your understanding, Mr. Silverthorne, everything you made a record on, including the possible other count in misdemeanor count, but we're looking at a full global resolution concerning these 2 files.
That's correct. The reason I made the statement is that I didn't want it to appear that the waiver was illusory, particularly since witness interference charges, has already been noted on the record, can be run consecutive to each other, which could mean a lot of stacking. And you know what stacking means, Mr. Walker, correct?
Yes,
On top of each other.
yes,
And so you feel that this is a fair resolution, is that correct?
yes.
Thank you, Your Honor.
All right, thank you. Now note for the record that Mr. Walker previously waived his 21-day rule on both files on February 2nd, 2024. Mr. Silverthorne, may I inquire of your client, Mr. Walker, of his waiver of the preliminary examination?
Yes, Your Honor, please do.
All right, thank you. Mr. Walker, you understand you have a right to a preliminary examination on today's date. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You are represented today by Attorney Dwayne Silverthorne, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding that it is your wish today to waive your right to a preliminary examination, have this case proceed to circuit court. There is going to be an added count of witness interference on each file with the understanding that there's going to be a global resolution, and they could have added multiple counts, but they didn't. So this is part of the negotiations to continue in circuit court.
Yeah.
It is my understanding, it is your wish today to waive your right to a preliminary examination on 23-03-607 and 23-03-443.
Your Honor,
Yes, Your Honor.
before the defendant answers that real quick, I just want to make sure we get the verbiage correctly. That not necessarily, so there is the potential for a global
Right.
resolution.
Right.
We're not making any offers
Right,
at this
right.
point.
Negotiations are to continue, and there's a potential for global resolution,
Yes, correct.
at least being reviewed for all the files that are out there.
Mhm.
All right, so once again, Mr. Walker, it is your wish today to waive your right to a preliminary examination on 23-03-607 and 23-03-443. Is that true, Mr. Walker?
Yes.
All right, and the people also waive their right to a prelim?
Thank you, Your Honor. The people unconditionally waive the right to a preliminary examination.
All right, I find the waiver of the prelim to be knowing, voluntarily, and accurately made, and I will give each. Do this and can get this, and I've got another one right here after that one. And we'll have each party sign the bind over notice. The second file. All right. While Ms. Wilson signing that, you can sign the second file. Thank you. All right, so I'm in possession of the signed bind over for 23-03-607. I'll indicate that the examination was waived on today's date. Now it's bound over as charged and then with the amended count pursuant to negotiations. And I will sign that accordingly. I will also sign on file 23-03-443 that it's been waived on today's date. And pursuant to negotiations, it's bound over on the charges in the complaint and the amended added to count for the previously discussed witness interference. I will also sign that. Anything else for the record in docket 23-03-607 or 23-03-443, Ms. Wilson?
Nothing to the people.
Mr. Silverthorne?
I'd briefly like to make a statement to defendant on the record.
Sure.
You continue to not have phone privileges that, as you recall, was ordered by the court a couple weeks ago. The prosecutor at this time has reserved the right to issue witness interference calls. I cannot speak for the prosecutor, but I would think that discretion could be influenced if you continue to call Chelsea Shannon the alleged victim. I am on the record telling you, obey His Honor's order, obey the order of your bond that probably put on by Madge. No, okay. Thank you.
All right, thank you.
And Your Honor, if I could add real quick, that does also include messages
Okay.
and video calls.
So it is not only the telephone contact, but it's also any contact.
Yes.
All right. All right. Mr. Walker, your time in district court is done. You're now on to circuit court, where you'll receive your next notice from your attorney, Mr. Silverthorne. Do you have any questions of me, Mr. Silverthorne?
Yeah.
All right. You're all set, Mr. Walker. Thank you for your appearance today. Thank you, Ms. Wilson.
Thank you. And I believe we're ready for Mr. Bursar.
Are we running that one?
No, we are not.
So many of these questions.
I was
I know.
gonna start doing the transcript forms and stuff. and We're gonna run it.
Week after. March.
March 13th.
Yeah, so 3 weeks. And so you'll be arraigned on this case either at the end of next week or beginning of next. We want to get things started by that probation regulation.
So we're on the record in docket 24-00187. That's people of the state of Michigan versus Wavon Verser. Will the parties please introduce themselves for the record, Ms. Wilson?
Abigail Wilson for the people.
Mr. Freeman.
Yes, Your Honor. Thank you. Stephen A. Freeman, Assistant Public Defender on behalf of Mr. Verser, who is seated to my right.
And sir, you are, and you correct my pronunciation, Wavon Verser or Wyvon Verser? Wyvon Verser. All right, thank you. This is the time set for a preliminary examination today. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that the defendant will be waiving his preliminary exam today with an additional count of, I believe would be count 2, felon in possession, and that is 750.224F. And that's a 5-year and/or, oh, I want to say it's 4,000. Let me double check.
It's a 5-year, isn't it?
5-year, yes. And/or $5,000 and mandatory forfeiture of the weapon. And then there would be an additional count 3 and 4, both a felony firearm, and that is 750.227.
I'm gonna have you repeat that.
Oh, yeah, okay.
Well, let's finish. So it's count 2 is felon in possession, and what's the PAC code on that?
Felon in possession is 750.224F.
That's an additional, that's 5 years and/or $5,000.
Correct.
And then count 3 would be the felony firearm.
Correct.
And that is pursuant to PAC code
750.227B-A.
to 2-year.
2-year, and it's to be served prior to any other conviction.
So that is the amended, so those would be the amended added count charges of 2, 3, and 4, and with count 1.
Correct, and the 4th charge is also the felony firearm.
Right.
Yes, yep.
Right, and then so I'm gonna restate that for the record, and my understanding is negotiations are continuing in circuit court concerning this matter.
Correct.
Let me, so I'll restate for the record. The request is that this will be waived and bound over on the complaint and the added charges. We'd add a count 2, a felon in possession pursuant to 750.224F. That's a 5-year and/or $5,000. A mandatory release of the weapon. And then count 3, a felony firearm, and count 4, felony firearm under 750.227B-A. That's a 2-year to run consecutive with anything that's sentenced. The 2 years are served off the top. Is that correct? Is that your understanding, Mr. Freeman?
I'm afraid it's not, Your Honor. If I may please address the court.
You may, if you need to talk to Ms. Wilson also concerning this matter.
Your Honor, we begin with the generalized proposition that motions by the prosecuting attorney to amend her complaint should be liberally granted. On the other hand, in my discussions with Ms. Wilson, my understanding, I believe that she and I had an understanding that if Mr. Verser insisted on going forward with preliminary examination this morning, that she would seek sufficient evidence from her witnesses and move the court at the conclusion of exam to add the counts that she just spoke of. I had a discussion with my client, and he and I came to an understanding that it would be better for him to simply waive his exam and allow this case to go to the circuit court with a single count of weapons, firearms larceny, as is currently stated in the complaint. So my appreciation was that if we waived exam, he would be bound over on the single count that the court now sees in the complaint, that any additional charges would only be forthcoming if we went forward with an examination hearing and proofs were sufficient to persuade the court to add those charges. So we believe that that was sufficient consideration to waive exam. And I indicated to Ms. Wilson, we were prepared to do that. She has released her witness. I now heard for the first time her proposal to add these 3 counts, even though Mr. Verser has agreed to waive his preliminary examination hearing. So on the one hand, I'm not suggesting that motions to amend shouldn't be liberally granted, but under these circumstances, I'm a little taken back, and I don't think I have any choice but to object to those, the addition of those 3 counts.
All right, so I don't know what the initial, I wasn't part of the discussions. I do know, I don't know if then there's an initial offer.
There was, Your Honor, and
Okay.
I have the email pulled up, and I specifically said in the
Right.
email
So
that if
let's,
there's a waiver, it has to be with the added counts.
okay, so let's do this. Why don't council meet? And I will hear both sides of the argument. The waiver of the prelim waiver can be, of course, on the offer with the understanding that counts have been added. If that's the decision of the parties, but I'll let council talk about it. We'll take about a 10-minute break and let council talk about it, and then we'll come back and put it on the record. Of course, we can have a prelim too if we need be, but that may mean, Ms. Wilson, you have to get your witness back, and I don't know if they're available, so we may be resetting it. But I'll let council talk, and then we can figure it out. Okay. All right. So let's adjourn for about 10-15 minutes, and we can come back and address something. 24-00187. If the parties had the opportunity to speak, and Ms. Wilson, how we proceed.
Thank you, Your Honor. So the people are willing to not seek the additional charges for bind over today, as long as there is an understanding that this may affect whatever additional deals are going on in his other circuit court case. And by this, I mean the additional case.
All right, so just for my purposes, that would be so you would not be seeking the amended charges of counts 2 through 4.
Correct.
All right, so I'm gonna strike that. After discussions. And then it'll be on the charge and the complaint bind over on the 5-year weapons firearm charge. Is that correct?
Correct.
All right. Mr. Freeman, is that your understanding of the bind over today?
Yes and no, Your Honor. Let me explain. I indicated to Ms. Wilson that while there was in my judgment, a misunderstanding or some confusion as to the particulars of this case this morning with respect to whether to have a hearing or whether the parties were going to mutually waive exam. Ultimately, as a matter of law, I believe that the prosecuting attorney's office is vested with sufficient prerogative to decide who's charged with what in this county, and that I would, my argument would not prevail because she has the law on her side. And so I was prepared to concede that, and that if she wished to amend the complaint and then move the court for bind over, I believe that the law would allow her to do that. And any argument to the contrary would not be a prevailing argument from the defense. So I guess, as they say, the ball is in her court. If she wants to continue and move the court for bind over on all 4 counts, I think as a matter of law, she has that prerogative and can do that. So I'll let her indicate to the court which is her preference. I withdraw any objection I previously stated to the court with respect to the addition of those 3 counts.
All right, so we're fair, Ms. Wilson.
We'd like to add the additional counts.
All right.
If there's not going to be an objection.
All right, so if there's no objection, I'm gonna need a new, well, let me see, I will, because I crossed them out, so I'm gonna reinstate.
I can just.
Yeah, we might need to. Counts 2, counts 3, and counts 4. I'm gonna reinstate, and without objection, we'll bind over on all accounts and then address negotiations are to continue in circuit court.
Correct.
All right. Is that your understanding, Mr. Verser, that you'll be, you're asking for a waiver on all 4 counts, negotiations are to continue? That would be on the charge complaint, count 1, and then the 2, 3, and 4 additional count of felon in possession of a firearm, which is a 5-year and or $5,000, and count 3 and 4, which are felony firearm, which are 2 years to run consecutive. The bind over will be on all 4 counts with negotiations to continue. Is that correct?
Well, there's a difference between appreciating it, understanding it, and being in favor of it. But the judge is simply asking, do you understand that? That's
The requested prosecutor bind overs on all 4 counts. Whatever negotiations are going to be can be in circuit court concerning what you ultimately either go to trial on all 4 or you plead guilty on 1 or 2, whatever's worked out in this global resolution. But the bind over is being requested for all 4 counts. Do you understand?
Where I'm confused at is she took them away and then you added them right back.
Well, there's been some negotiations ongoing.
Yeah, that's where I'm confused.
Right. What? So there's no confusion. If you waive today, you're waiving on all 4 counts. If you choose not to waive today, then I think we'd have to reset it. Yeah, we'd have to reset the prelim so that you could have a prelim on all 4 counts. So is it your choice today to waive on all 4 counts or to have me set this for a hearing in the future?
I'm set.
All right. All right, so you understand the nature of the agreement to waive on all 4 counts and have negotiations continue. All right. Mr. Freeman, I'm already inquiring of your client, so I'll go on and inquire. May I inquire your client of the waiver of the prelim now that he understands the nature of the bind over?
Of course, Your Honor.
All right,
Your Honor,
thank you.
before you do that, if I might just, for clarity on the record, there's been talk of the additional case up in circuit. It's my understanding there have been no negotiations, but no firm offer or anything. This would go up and negotiations would continue on the 2 of them.
Right, and any global resolution concerning anything else. All right. All right. Mr. Verser, you understand you have a right to a preliminary examination today. A right to a preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Steve Freeman, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan, represented by Ms. Wilson. It's my understanding it is your wish today to waive your right to preliminary examination on the 4 counts that we've previously discussed and have negotiations continue in circuit court, which is a trial court. Negotiations continue in circuit court concerning the global resolution of all these potential matters. It is your wish today to waive your right to a preliminary examination on these 4 counts. Okay. Do the people also waive their right to a prelim?
Your Honor, we unconditionally waive our right to preliminary
Okay.
exam.
I find the preliminary examination to be knowing, voluntarily, and accurately made. And for purposes of bind over, I'm going to provide the paperwork for the bind over. I've written in all the additional charges and then crossed them out, but they'll be reinstated in circuit court. I just put reinstate there, but that's why it looks a little messy. Okay. All right. So I'll have all the parties sign it. I think the record will speak for itself. Yeah. Yeah, just in case. And then I'll write it on the ROA too.
I'll just lay out.
Yeah, it's all.
As best you can. That's what he just read to you. As best you can.
I'll indicate for the record, I'm in possession of the bind over notice. If the examination was waived on today's date. I will sign the bind over to that effect. I will also write on the art register of actions that this is bound over as charged with the additional three counts on the bind over notice. So, Mr. Verser, your time in district court's done. You'll be in circuit court where you'll get your next notice to appear from your attorney, Mr. Freeman, probably in the next 2 weeks. All right, sir? All right, anything else for the record in 2400187, Ms. Wilson?
Have a go. Nothing for the people, Your Honor.
Mr. Freeman?
Nothing further, Your Honor. Thank you.
Thank you. Okay, that's all for the record in this file. Thank you for your appearance today, sir.
Giving us those 10 minutes was a good idea.
Well, it couldn't hurt. Maybe it could.
Yeah, go ahead. I gotta come out to the jail to see you between now and next Wednesday anyway. We'll have a good discussion.
All set, Mr. Freeman?
Yeah, I think so. Did I need to call her?